And greetings. Oh, Lord. There we go. And welcome to Police Misconduct as Municipal Policy. This is from the Proof of Facts in American Jurisprudence. This is going to be a little bit different than the other American Jurisprudence streams because this one is going to be focused on the Proof of Facts, which is going to be the elements of the case that would be brought against any of these misconduct allegations to bring them to the courts to have them brought to justice. So, with that being said, we're going to have Black's Law Dictionary, 9th edition here, to make sure that we leave no word behind. And if there's any other references to other editions of Black's Law, it will be within the Proof of Facts, but typically the 9th edition should be new enough for most interpretations without any kind of backlash. And what we're going to be going into here is the police misconduct as municipal policy or custom. And this is from the American Jurisprudence Proof of Facts, 3rd edition. And this was originally published in 1991, but we're going to be reading the April 2023 update. So this is very current. So all of this should be applying to anything that would be currently happening to anyone out there that would be interested in this. So let's see. Salty Siren, glad you can make it out here. Finally. So this is going to be an exciting one here because we're going to take some suggestions here, and I guess we could do it through the chat. I have a few from a community post I made earlier, and this will be including the article outline here. So we have all these different parts that we're going to go over here, the introduction, and we're going to look at all these different sections here, but what we'll be able to do is go into specifically certain ones that are going to be of interest to this audience here. And as we get down here, we also have an index with some more terms that we could get into with the direct references to them. So code of silence, collateral estoppel, things like this, color of law. So we could get directly into these things, and we're going to look at some of the general issues first. But just to let you know that we'll go through this too if we can't find enough content right from these particular causes, elements of cause here. So here's the article outline. Again, this is the elements of cause of action, or what we will choose from. I'll go over this introduction. If you wish, you could look also at the community post I have, and there's this whole list of all of these listed there for you to choose from, and you could just list the section number and what it is, and then we can reference that within this live stream here. That being said, what I'm going to do is start reading from the introduction here on sections 1 through 4, so we can see in general the modern application of section 1983, the scope of this article, the creation of municipal liability, the Monroe and Monell, which we've heard of before, but we're going to get into strict details of this as concerning the proof of facts, and section 1983 and respondent superior. And then we'll get down to the elements of causes of action as selected by the audience tonight. So let's get started. So down here, geez, it's a long index too. Here we go. So the background in general, the introduction, section 1, cumulative supplement. Let's make sure it's all centered nice on screen. Looks good. So the 14th Amendment to the United States Constitution provides that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. It further provides that the Congress shall have the power to enforce, by appropriate legislation, the provisions of this article. The 14th Amendment, which was proposed to the legislatures of the several states on June 13, 1866, little more than a year following the end of the Civil War, reflected a national vision that the Constitution guaranteed the personal liberties of all citizens. The Civil Rights Act of 1871 created the tools necessary to transform that vision into a concrete embodiment of civil rights protection. That act is now codified in 42 U.S.C. 1983. In pertinent part, Section 1983 provides as follows. 14. Let's see here. Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state, subjects or causes to be subjected any person to the deprivation of any rights secured by the Constitution shall be liable to the party injured in an action at law. Every person who, under color of any statute, ordinance, regulation, custom, or usage, that's pretty broad there, of any state, subjects, or causes to be subjected, right? This is our verbs here. Any person to the deprivation of any rights secured by the Constitution shall be liable to the party injured in an action at law. So that gives you your cause of action. So let's see here. How are we going to get this cause of action, right? This is an action in law. So what this will be defined as in our motions here will be our causes of action. But before we can get to that, I have to first say that none of this should be interpreted as legal lawful advice to use in your personal, private, or professional life in any way, shape, or form. This is strictly for entertainment and educational purposes, not to be construed as anything other than that of this performance here tonight, and do not do this at home. Okay, let's continue. So here we have in the cumulative section, we have the Bivens actions and the trial strategy, which is obtaining damages in federal court for state and local police misconduct, 62 AmJur. We can check that in AmJur trials, but that would be a different stream. All right, give me one moment here. Make sure everything is running smooth before we continue. It looks good there. I'm just checking stream health. Looks like it's all streaming good. Let's continue here. Okay, so the cases. A. Bivens action is the federal analog to suits brought against state officials under 1983. It provides victims of a constitutional violation by a federal have a right. Wait, hang on a second. This is kind of weird writing here. Okay. Is a federal analog to suits brought against state officials. It provides victims of a constitutional violation by a federal have. Oh, it provides victims of a constitutional violation by a federal have a right to recover damages against the official in federal court, despite the absence of any statute conferring such a right. 42 U.S.C. 1983, Hartman versus Monroe. West's key number. Okay, right. Custom or policy. In quotations here, right? So this is exact wording here. Supporting recovery against a governmental entity under 1981 or 1983 can take one of three forms. So here are three forms of their customs or policies. One, an express policy that, when enforced, causes a constitutional deprivation. So there's an express policy, usually written, right? That's what they mean by that. It's express, like go out and do this and deprive him of his rights. Two, a widespread practice, right? Now we're not talking about express policy, but a widespread practice. To distinguish between practice and policy. Policy is what you're told to do, and practice is what you do. That, although not authorized by written law or express municipal policy, is so permanent and well settled as to constitute custom or usage. Important wording here. Look, custom or policy in quotes, custom or usage in quotes, take notes. With the force of law, or, okay, so number two is a widespread practice, although not authorized by written law or express municipal policy is so permanent and well settled as to constitute customer usage with the force of law, which it's not really supposed to have. Or 3, an allegation that the constitutional injury was caused by a person with final policymaking authority. Final policymaking authority. Interesting distinction about who will have the personal jurisdiction here. Thus, custom or policy may be established by an allegation that the constitutional injury was caused by a person with final policy-making authority. And here's a case to support that. To establish a Section 1983 violation, a plaintiff must show that, here we go, here's your test you have to do. 1, a policy or custom existed. So either a custom or policy, right? The governmental policymakers actually or constructively knew of the policy's existence. 3, a constitutional violation occurred. And 4, the custom or policy served as the moving force behind the violation. So the custom or policy had to serve as a moving force behind the violation. 42 U.S.C. 1983, and here's our City of El Paso case law 2012. So let me check out in the chat here really quick before we get to section 2 here. All right, let's see what we get here. We get you have rights, cops have duties. We need to, this part, a lot of this should hopefully be applying to what you're going to be going through here. I'm hoping you're going to throw up some sections in the chat that we're going to go over that may apply for you. And your video on trans. No, I know none of those videos. And cancel all contracts with bench warrants. Yeah, well, depending how they were constructed, perhaps. You never know. But we'll see what's in here that might help. Luddite, yeah, it's easy to figure out. This is common law. Common law is for everybody. And yeah, you have rights, cops have duties. This is interesting. But isn't that kind of how they all are? All right. Let's continue here. Oops. All right. So let's continue on section 2, the modern application of section 1983 in the scope of article. When enacted as the Civil Rights Act of 1871, what is now section 1983 was largely intended to use the power of the federal government to remedy the abuse, especially against blacks, perpetrated by state government representatives under discriminatory laws existing in many southern states, and to deal with the failure of Southern officials to enforce existing laws against the Ku Klux Klan. Nearly a century passed before the courts began to approach Section 1983 in a way that revealed the potential breadth of the protection it afforded. The statute creates no substantive rights. It only provides a means of enforcing federal rights that have been conferred elsewhere. It was the United States Supreme Court's application of the statute to government officials in 1861 in Monroe v. Pape, see Section 3, and to municipalities in 1978 in Monell v. Department of Social Services of the City of New York, see Section 3. We'll be there in a second. That greatly expanded the power of the statute to redress and deter official misconduct which infringes on the constitutional rights of citizens. The court's expansive attitude towards a statute facilitated the civil rights movement of the 1960s and dramatically increased the number of Section 1983 cases. The Monroe and Monell cases have been followed by a series of federal court decisions which have attempted to delineate the scope of Section 1983 as it applies to municipal entities. That's your local cop shop. Although the courts have uniformly held that the use of excessive force by law enforcement officers may constitute a denial of due process for which an action for damages lies under Section 1983, The limits of the use of Section 1983 against municipalities have been the subject of some disagreement among the courts. This article will examine the parameters of a Section 1983 action where liability is sought to be imposed on a municipality based on the excessive use of force by a law enforcement officer. Closely related actions under Section 1983, such as the numerous decisions concerning failure to provide medical attention to a person in the custody of law enforcement authorities, or the failure of such authorities to prevent the suicide of a prisoner, will be dealt with only to the extent that such cases are relevant to the cases involving excessive use of force. Interesting. So I can kind of see little tinges of that qualified immunity from here, huh? Now, granted, what we're really investigating here is the fact that long-standing common law is being perverted and in recent court decisions by so-called liberal judges, and it's really corrupting the very strength of our common law nation here. And by figuring out the strength of common law where it really stands against this, we have to enforce it, because otherwise it's just going to be ignored by the municipalities and the other ones that try to get around our common law rights. This is the way that we keep our power and make sure that it's enforced all the way, because it's been enshrined within too much of our country's documents to be ignored. Yet too many people want to ignore it and run to the wrong things. That's left us in a bad position. So that being said, by having a wide understanding of this, we want to be able to come at a position, should we ever be confronted in these situations, where we can have more knowledge, logical reasoning, and hopefully some wisdom, that we can construct our emotions to be more powerful, compelling, and truthful and honorable than any of our defalcating opponents. Let's continue here. So some of the cases here, 1983 plaintiff. So bear in mind these things here. These are precautions and pitfalls. 1983 plaintiff bears the burden of identifying the policy or custom required for a municipality's liability. So this rule ensures that a municipality will only be liable where it is the moving force behind the plaintiff's injury. So remember, we read something about this, about the moving force behind the injury. And what we say here is that the plaintiff bears the burden of identifying the policy or custom. Again, we're looking at causes here, right? And elements of the cause of action, and elements of policy or custom. We, as a plaintiff, would have the burden of identifying that policy or custom required for the municipality's liability. So this rule ensures that a municipality will only be liable where it is the moving force behind the plaintiff's injury. And that's 42 U.S.C. and then Section 1983. This 2014 case, see how current these are. So it's kind of scary. Typically, a municipality is immune from 1983 liability, unless it can be shown that the unconstitutional actions it is charged with committing are the result of a municipal policy or custom. 42 U.S.C.A., that's 1983 section, right? Again, and we have a Michigan case, 2015. City and city police chief were not subject to liability in action brought under 1983, based on purported ratification of police officers' allegedly unlawful use of deadly force, in violation of plaintiff's Fourth Amendment rights, arising out of officers firing multiple shots into plaintiff's vehicle as vehicle was moving toward one of the officers, and after plaintiff accelerated the vehicle based on city police department's internal investigation into shooting and police chief's approval of results of investigation into incident, which exonerated both officers, absent any showing of other flawed internal investigations where either city or police chief failed to take disciplinary action when his officers allegedly violated law. Yeah, okay. 2021, of course. Look how close this is. And this is, where is this? Uh, 11th Circuit. Oh, that's Florida. Interesting. So which case is this? Underwood versus City of Bessemer. It's not Florida, it must be Georgia. Okay, so pre-trial, detainee stated 1983 municipal liability claim against County Board of Commissioners based on theory of failure to train rising from alleged assault on detainee in jail, in which deputies allegedly assaulted him by firing concussive grenades in his directions and striking him once in the head while he lay face down on the floor of a small room. Complaint alleges that deputies exceeded constitutional limitations on use of force, that deputies were trained to intimidate and be unnecessarily aggressive and violent with detainees, and to escalate use of force against detainees unreasonably and precipitously, and that there were ongoing constitutional violations in jail, which prompted United States Attorney to launch inquiry into alleged civil rights abuses in jail. And this is in Colorado, 2021. So as you can see, this stuff is still being decided to this day, and it's not a good thing that these long-standing common law principles are being, affronted by municipals and their policies and customs. All right, let me check the chat here, make sure everything's looking good. If sounds good and everything, just please make sure we know. I know, and if there's not, let me know that too. All right, let's see, Brian B's here. And El Pero, welcome. Sir, all right. Let's continue on here. All right. So again, that was a little crazy what they do here, and to think that in books like this, where you have this kind of language here, lay face down on the floor of a small room, and concussive grenades in his direction. I'll say this is that I would probably guarantee that most law students aren't poring over it like we are right here. So I want to salute everyone that's here tonight and spending the time to go over this, because I believe this is going to be something that's going to help everyone out there more and help those that have the duties to be held more responsible and accountable for what they're doing. All right, let's proceed. All right, Scott says all good. Thanks. Great. All right, so to state a 1983 claim against a municipality, plaintiffs must 1. Identify a policy or custom that deprived them of a federally protected right. Identify a policy or custom, so we need to find that policy or custom. See, this is the elements that the facts. Remember, we're talking about proof of facts here. So although we have American jurisprudence, we're trying to take a common law overarching approach here. We still have to respect the fact of case laws, because that's the the essence of common law was built from case law to get the letter of the spirit. The problem is that the liberal judges are changing well-standard case law, so it's being detached from the actual meaning of what it should be doing. And these are hurdles, but they're not hurdles that we can't find the proper strategy to get around. And that's part of what the proof of facts is that when you have facts unrebutted, they stand as truth. And that's what we aim to do here, is to take the things that are truth and make sure that they can stand as facts that will be admitted as evidence in the proper cause of action, so that it has standing and we can get a judgment, a ruling in favor of justice. All right, let's continue. So to state a 1983 claim against a municipality, plaintiffs must 1. Identify a policy or custom that deprived them of a federally protected right. 2, demonstrate that the municipality, by its deliberate conduct, acted as the, quote, moving force behind the alleged deprivation. And 3, establish a direct causal link between the policy or custom and plaintiff's injury. So we want that legal nexus, the causal link between the policy or custom and the injury, the plaintiff's injury. 2009, Delaware. Without proof, without proof, that means an unrebutted allegation here with facts of a custom or policy that further the allegedly unconstitutional behavior of police officers. County was not subject to liability under Section 1983. Bloom versus Miami-Dade County, 2011. Without proof, the county was not subject. So we need to have proof of a customer policy. Sounds like Bloom isn't the one you want. Geez, Miami-Dade. Talk about a mafia Dade there. Can't imagine they have a policy or custom that isn't unconstitutional, but I digress. All right. Where a 1983 suit is brought against an individual in his official capacity, it is really a claim against the municipality, and hence a plaintiff must show that the municipality maintained an express policy of depriving its citizens of their constitutional rights. That its practice of depriving citizens of their constitutional rights, though not authorized or not written, was so widespread so as to have the force of law, or that the individual in question was a person with final policy-making authority who made a deliberate choice to either deprive plaintiff of some constitutional right or acquiesced in such a deprivation, turning a blind eye for fear of what he might see. So, this is North Dakota, 2006. So, you have rights, cops have duties. Take note of how we're breaking these cases down here and try to find any of them where they'd have similarities as far as the causal links of where you see these successes in the cases, and then when you see the failures in the cases, like this one, Bloom versus Miami-Dade County. Again, you want to identify, you want to have proof of that customer policy. It can't just be a mere allegation. It needs to be an allegation substantiated with facts that stand unrebutted. And that could be admitted as evidence, so it can't be privileged information either. You can't say, well, somebody told me. It has to be something that everybody else can agree that it is a fact, and it can stand the scrutiny of a rebuttal. So focusing on customs or policy, as you can see, and that's another thing I like about American jurisprudence, and it may seem redundant or I've reread something, but I haven't, because it all makes sure that the important parts are repeated enough in as many different ways so that you can see how they actually connect with the strategies and the approaches that you take when you're trying to express any of these lawful expressions. All right, let's go on. So we have allegations. Here's another case here. Allegations of representatives of pre-trial detainee who suffered from mental illness and other physical conditions, and who died while incarcerated. That sheriff and warden were repeatedly informed of the detainee's perilous medical state, as confirmed by detainee's apparently insistent complaints, his doctor's own prescriptions, his family's continual calls, and prison's own notes and tests. That when the detainee asked for a wheelchair, his request was denied for no apparent reason. and appointment with psychiatrist scheduled instead. Gosh. And when detainee suffered shortness of breath, he was instead placed on suicide watch for bizarre and abnormal behavior. Stated 1983 conditions of confinement claim based on due process violation against sheriff and warden in their individual capacities. Appeal dismissed. So that stood, right? Yeah. They put an appeal and the appeal was dismissed. Municipality may be held liable under 1983 when execution of a government's policy or custom, whether made by its lawmakers or by those whose edicts or acts may fairly be said to represent official policy, inflicts the injury. So they could be held liable, the municipality, when an execution of a government's policy or custom, whether it's made by lawmakers or those whose edicts or acts may fairly be said to represent official policy. See, may fairly be said to represent official policy, inflicts the injury. Edicts or acts. This is pretty good language here, too. I want to get back to this for 1 second, though. Let's see. No one caught this here, but did you see this here that they mentioned? The sheriff, let's see. So much to use long sentences. Here we go. Okay, state 1983 conditions of, here we go, listen to this, confinement claim based on due process violation, right? So focus on this, guys. This is a successful case in 2016, and the appeal was also dismissed, so it stood. Based on due process violation against sheriff and warden in their individual capacities. Interesting. So this is something where it's because of their acts, not necessarily because of an express policy. So here's where an example where the act is enough to convict, it seems. Again, I'm no legal expert here. I just want everyone else to try to read in. If I see this wrong, then please pipe up in the chat and let me know. All right, let's continue on here. To establish a municipal liability under 1983, a plaintiff must demonstrate 1, an officer committed an underlying constitutional violation. Okay, so it's going to be an officer, right? For the municipal, some officer committed an underlying constitutional violation. 2, a municipal policy or custom exists. And 3, there is a direct causal link between the policy or custom and the injury alleged. And that's New Mexico, 2014. Man, some new cases here. To establish municipal liability under 1983, based on city's failure to train its employees, plaintiff must show, wow, this is, pay attention on this one. This looks really good because this gets into training, which we all know is not the usually the highest priority of these municipalities, should I say. So to establish municipal liability under Section 1983 based on city's failure to train its employees, plaintiff must show that 1, policymaker knows to moral certainty that her employees will confront given situation. Knows to moral certainty, wow, that her employees will confront the given situation. 2, situation either presents employee with difficult choice of sort that training or supervision will make less difficult, or there's a history of employees mishandling the situation. And 3, wrong choice by city employee will frequently cause deprivation of citizens' constitutional rights. This is 2019. So to establish, plaintiff must show these three things. One, policymaker knows to moral certainty that the employees will confront the given situation. Moral certainty. So you can't say, I didn't know, when you know that moral certainty. This is an interesting concept. And two, the situation either presents the employee with a difficult choice of sort, that training or supervision will make less difficult. So their certainty that they will be confronted a given situation, right? So that they know they should have training. There's a certainty. And the situation presents the employee with a difficult choice of sort that training or supervision would make less difficult. So that means that they need to be there, the policymaker or supervisor. Or if there's a history, here's another one. This still suffices for number two because there's an or. It could be either the situation with a difficult choice with all that language, or there's a history of employees mishandling the situation, this given situation. There's a history, and that could be documented within public records usually. And three, wrong choice by city employees will frequently cause deprivation of citizens' constitutional rights. So if they make the wrong choice, it will frequently cause a deprivation of citizens' rights. So, interesting case here, 2019 New York. All right. Almost every time an officer commits, oh, come on, get up there. Jeez. There we go. Yeah, almost every time a policy officer commits fraud, it's each and every time. Yeah, because anytime they do a half truth or a omitted fact to mislead by intent, it is fraud. Okay, so let's continue. There was no evidence that several employees of a city police department partook in any of the actions that formed the basis of arrestee's 1983 claims, stemming from his arrest, murder conviction, and subsequent exoneration. And thus, arrestee could not succeed on claim as to those employees. So here's an unsuccessful one here. Employees did not take inculpatory statement that led to arrestee's arrest, did not participate in the arrest, and did not initiate or set into motion the murder prosecution against arrestee. So he picked the wrong employees, looks like. I don't know. After looking at that one, that's 2021, so not very long ago. Be aware that, when we're studying something like common law that's ancient, and you see cases like 2021 affecting, some of these things like proof of facts, we're looking at a April 2023 supplement here. So this is all being updated to make sure that this is what the state of affairs is right now. So you don't want to be the first one to figure this out, what works and what doesn't. And that's kind of why we're going over this right now. Let me see how many more cases there are here. Not many more. And then we get on to the creation of the municipal liability. But this really illustrates the concepts we're talking about here of these things like the elements, the policy and their express policies, their practices, the motion, the motives, the moving force. Okay, let's continue here. To state a claim based upon municipal liability under 1983, once a plaintiff identifies a municipal policy or custom, he must demonstrate that, though through its deliberate conduct, the municipality was the moving force behind the injury alleged. And here's 2014 in Pennsylvania. So these are the cases that would support your legal conclusion based on perhaps your situation. Oh, these judges agreed and it stood, and this is the same logic and reasoning I'm using, and the facts are of the same nature. Therefore, this would apply right here. So to state a claim, and not saying they always are going to buy it, that's why we want to go to the precautions and the practice tips here too. And oops, what happened here? Oh, come on, not really. A moment here, we'll bring us back. One moment. old, so refresh that guy there. He'll come back. Do one more refresh here. All right. Okie doke. We're back. So I hope everyone's picking for some of these sections here to go over because there's too many to go through. But we want to pick some. Look, there's going to be some good ones. I'll mention a few of them before we continue here. Just to get you wet up for the excessive force under color of law, deprivation of constitutional right. Oh, look at this here. Strip search policy, use of police dogs, deadly force policy, sexual assault, enforcement of law. This is a particular policy or custom, right? Then we have final decision-making authorities, failure to screen applicants, discipline, train or supervise, policy or custom. See, informal policy or custom, we're going to find how to identify these things under Section 10, evidence of policy or custom, right? Because we need to have proof of facts. That's what this is all going to get into. So practice applications, parties in standing, pleadings. We have all this stuff here, and we'll go over whatever we want to do. Attorney fees. Remember, you're going to charge this if you're going through this trouble. And you want to know how to charge your attorney fees for this. Punitive damages, all that goodness there. See, departmental acceptance code of silence. Hindrance of prosecution of police officers, standard of care, documentary evidence, failure to use red flag system, inconsistent discipline, use of prohibited weapons, policy making authority of police officials. There's a lot of good stuff in here. And then we have the index where you can get to specific things here too. If there's something in that's not in that section, but we want to get into like the but-for causation, the bright prospect standards, burden of proof. These are some things that are interesting concepts. Code of silence, collateral estoppel, that I think everybody should know. This should be basic knowledge for every American. All right. Let's get back to where we were here. All right. All right, so here's some more dark ones we got to go through. Let's just get through this stuff while we can. Allegations that the city and its policymakers promulgated policies or practices of using deadly force prematurely and using excessively deadly force. That over previous decades, city violated its citizens' rights by arresting citizens who video recorded police, attacking demonstrations with horses, obstructing freedom of press, and disrupting lawful demonstration. I wonder where this could be. That city police officers routinely use excessive and deadly force. That officers had killed or seriously injured many citizens doing nothing wrong during previous few years. That such policies or practices were actually or constructively known by the city, and that policies or practices caused death of resident who was shot and killed by police officer, did not state 1983 municipal liability claim against city, absent any factual allegations identifying policies promulgated by city policymakers, or provide specific examples of persistent and widespread constitutional violations. This is kind of interesting. So what was the case? Well, we'll have to look this one up. 2015. Here it is. Schaefer versus Whited. All right. To be actionable under Section 1983, a county employer's custom or policy must exhibit a deliberate indifference to the rights of inhabitants. Moreover, the custom or policy must cause a constitutional violation. So, interesting language. To be actionable under 1983, a county employer's customer policy must exhibit a deliberate indifference to the rights of inhabitants. That's another one. Inhabitants. Interesting term here. Let's take a quick break and see what Black's Law has to say about inhabitants. Because this is a word. We're just going to see if we can find it like this. Moment here. And try to find some sections and throw them in the chat. I haven't seen any sections in the chat for suggestions. Sections for suggestions would be great to see in that. And again, I have it pinned at the top of the chat for the link to the community page that has a list of all those. So you could just jot down a couple numbers. I have a couple here, 12.7 and 31 that people have already requested. And I'm ready for more. All right. So we're looking for inhabitants here. Yeah, bear with me. This really moves slow. It's a scanned document of the Black's Law, so it's not, it's as easy for me to share with you all, but it's not easy to search or scan through. Here we go. Okay, so we can get up a little bit. All right, almost there. Close. Wow, a lot of J's. Okay, here we go. Inheritance. Jeez. Inhabit. 14th century. To dwell in. To occupy permanently or habitually as a residence. So this is an interesting word here because this would be a 14th century term, to dwell in. Very simple. You're not given any jurisdiction like a citizen or resident. It says as a residence, something like never is the same. So like as is a simile. It's not the same. So you could not say inhabitant is a resident, although it as a residence, habitually as a residence. But to dwell in, that's simple enough. Inhabit. So that's a good term. All right, so that was worth the digression. Let's continue. To be actionable under 1983, a county employer's customer policy must exhibit a deliberate indifference to the rights of inhabitants. Moreover, the custom or policy must cause a constitutional violation. So it has to be a policy must exhibit a deliberate indifference, meaning that you deliberately do not discriminate. Not just by chance, I didn't this time, but it has to be deliberate. I consciously make sure I don't discriminate, however that works. Okay, town employee with final policy-making authority did not act to create audio surveillance system in town hall, and thus town was not liable under 1983 to town hall employees who alleged their civil rights were violated when they were subjected to hidden audio surveillance in town hall. Jeez. Did not act to create it. So police officers and town employees who were alleged to have been responsible for surveillance did not have final decision-making authority to implement surveillance. Town council, which had power to make decisions for the town, never authorized creation or operation of audio surveillance system in town hall. And even if police chief ordered and oversaw installation of the town's hall security system, police chief was only final policymaker for police department, not for the town. Jeez. Transfer denied. Indiana, 2021. 2021. All right, so you guys get this. This is the little crap they'll pull. So be aware. This is what we're doing this for, so we can be aware. These are new little twists and turns they've pulled. And they're little shyster games, if you ask me. Pettifogger, shyster, esquires. All right. That's the end of that supplement. So salute to you all for sticking with that. That was some pretty heavy learning there. And we really dug into those cases to understand each of those was put there as a purpose so we have a good understanding of the application in the proof of facts of these elements we just discussed. And now we get on to the creation of the municipal liability, the Monroe and Monell. So, two great watershed cases on the subject of municipal liability under Section 1983 are Monroe versus Pape and Monell versus Department of Social Services of the City of New York. Although the great majority of Section 1983 municipal liability cases involve allegations of use of excessive force by law enforcement officials, neither Monroe nor Monell is an excessive force case. In fact, of the two cases, only Monroe involved improper conduct by police. Nevertheless, these two decisions made possible the application of remedies under Section 1983 for the unconstitutional use of excessive force by police officials and their municipal employers. Saw a comment here. It's pretty bad there. When I was in prison, the print on the outside of boxes of food said, "Not for human consumption." It might not be so bad if they were giving you raw milk, but for some reason I don't think that's what you were drinking there. Yeah, it was an illegal thing, I think. All right. In Monroe, the court held that municipal officials may be sued as individuals under Section 1983. The actions taken by those officials, even though in excess of their authority, were still under color of law. The court also determined that the federal remedy provided by Section 1983 was supplementary to available state remedies. So a supplement, right? It was supplanted. So to available state remedies, and that Section 1983 should be read against the background of tort liability that makes persons responsible for the natural consequences of their actions. This directive helped establish the concept of constitutional tort and has guided the courts on many occasions interpreting Section 1983. The court also held, however, that Congress had not intended to include municipalities, distinct from municipal officials, as persons subject to the Act. Monroe therefore held that municipalities were not subject to liability under 1983. So, this is something that we want to take apart some other time in a little bit more detail. But do you see how this is done here, right? So, following that decision in Monroe, municipalities were shielded for nearly 2 decades from Section 1983 liability. In 1978, however, the landmark case of Monell versus Department of Social Services of the City of New York, the Supreme Court reversed itself, overruling Monroe versus Pape, insofar as it held that local governments were wholly immune from suit under 1983. Jeez. In Monell, the court held that Congress had intended municipalities and other local government units to be included among those persons to whom Section 1983 applied. Therefore, local governing bodies and local officials in their official capacities may, said the court, be sued directly under Section 1983 for monetary, declaratory, and injunctive relief in those situations where the action that is alleged to be unconstitutional implements or executes a policy statement, ordinance, regulation, or decision officially adopted or promulgated by those whose edicts or acts might fairly be said to represent official policy. So let's digest this long sentence one more time. Local governing bodies and local officials in their official capacities may be sued directly under Section 1983 for, monetary, declaratory, and injunctive relief. So our equitable relief here too. In those situations where the action that is alleged to be unconstitutional implements or executes a policy statement. So the action as alleged to be unconstitutional implements or executes their policy statement. So they say this, they execute that statement, okay? It's a statement, a policy statement, It's an ordinance, it could be a regulation, or a decision officially adopted or promulgated by those whose edicts or acts may fairly be said to represent official policy. In addition, local governments, like every other Section 1983 person, in quotations, may be sued for constitutional deprivations visited pursuant to governmental custom, even though such custom has not received formal approval through the government's official decision-making channels. So, another one to digest here. So, again, you need to make sure that you'd have a clear understanding of any of this before you initiate a case, because these are the pitfalls you want to avoid before you get lost in the weeds. Let's look at this one more time here. Governing bodies and local officials in their official capacities may be sued directly, right? In situations where the action is unconstitutional, implements or executes a policy statement. So the alleged action implements or executes a policy statement, ordinance, regulation, or decision officially adopted. It could be officially adopted or promulgated by those whose edicts or acts might fairly be said to represent official policy, like the chief. In addition, local governments, like every other Section 1983 person. Come to think of it, I wonder if they could even consider this the dispatcher in some cases. That might be a stretch. Okay, like every other Section 1983 person may be sued for constitutional deprivations visited pursuant to governmental customs, even though such custom has not received formal approval through government's official decision-making channels, laws, policies, codes. However, the court held that Congress had not intended municipalities to be held liable under Section 1983 unless action pursuant to municipal policy or custom caused the constitutional tort. In particular, the court concluded that a municipality may not be held liable solely because it employs a tortfeasor. You know what a tortfeasor is, right? Someone that's doing something bad out of a bad intent. In other words, a municipality cannot be held liable for Section 1983 on a respondeat superior theory. Instead, it is when injury is inflicted by execution of a government's policy or custom, whether it's made by its lawmakers or those who edicts or acts may be fairly said to represent official policy, that the government as an entity is responsible under Section 1983. The court did not address what full contours of municipal liability under Section 1983 might be, and expressly left further development of such an action to another day. Good. So this is an interesting one too. Monell. So this is a study in and of itself, the Monell. Under Monell, a policy need not be formal or written to be actionable. You get that? It doesn't need to be formal or written to be actionable. But the court made it clear that the policy requirement of Monell was intended to distinguish acts of the municipality from acts of the municipality's employees, and that municipal liability is therefore limited to actions for which the municipality is actually responsible. Recovery from a municipality is limited to acts that are, properly speaking, of the municipality. That is, acts that the municipality has officially sanctioned or ordered. This rejection of respondeat superior liability for municipalities under Section 1983 is also reflected in the requirement that the policy or custom of the municipality must have caused the harm of which the plaintiff complains. The Monell decision left unanswered several important questions surrounding the proof of municipal liability under Section 1983. Most importantly, the court failed to define either policy or custom. So, in fact, the term policy itself does not even appear in Section 1983. The court also failed to explain what kind of municipal employee is in a position to make policy, and it did not discuss how a plaintiff may establish causation. These issues and many others have been the subject of many subsequent cases which have addressed the question of municipal liability for constitutional torts. All right, guys, good stuff here. So there's more cases. How many cases? Oh, shit, there's a lot of cases here. Okay, so we've done our due diligence of cases so far. The Monell stuff is, again, like I said, a study in and of itself, so we'll leave that for another day. And that's the end of that supplement of Section 3.5 here. And let's see. Yeah, we need to get to our elements here. So let's move ahead. I'm waiting for some more numbers in the chat so we can get to doing the. Yeah, there's a lot of cases here, guys. But we did a lot of the basic ones there, and now we're going to get into some of the more nuanced stuff. So, but there's good stuff here. Sheriff's deputy was not an official policymaker for the county, and therefore county could not be liable under Section 1983 for deputy's actions in purportedly arresting landowner after responding to dispute between neighbors over the use of irrigation water. Though deputy was given some discretion in exercising the authority she held as deputy for the sheriff's office, her actions, though discretionary, were still constrained by other policies, and deputy's decisions were reviewable by others. So see how that works. So cause of action, Section 4. So here we get to, now we're getting into the causes of action. Okay, this is the elements of cause of action. So cause of action against a municipality for the excessive use of force by a law enforcement officer consists of 5 elements. You ready? 5 elements. First, it must be shown that one or more officers engaged in the use of excessive force against the plaintiff. Whether excessive force was used under the circumstances is usually a question of fact for the jury. There is no requirement that the evidence show that the plaintiff suffered a severe injury at the hands of officers for unconstitutionally excessive force to be found. Second, the actions of the law enforcement officers must have been taken under color of state law. Actions taken by an officer may still be under color of law even though they are in excess of the officer's authority. Furthermore, the fact that a police officer was off duty at the time the officer committed the act complained of is not itself determinative as to whether the act was under the color of law. Although the acts of police officers in the ambit of their personal private pursuits fall outside of Section 1983, the lack of the outward indicia suggestive of state authority, such as being on duty, wearing a uniform, or driving a patrol car, are not controlling. Rather, the nature of the act performed must be examined. Nice. Then we have some more cases. All right, let's look at this one here. Let's see what we got in New York. Policymaker. We go on and on with this stuff here. Security chief at private pork processing. Yeah, these can go on and on and on. But we got to get down to the list to the numbers of these different causes so we can have some fun with the panel here, or the chat, the audience. Pro se detainee adequately alleged that county jail sergeant was personally involved in an incident which corrections officers forced detainee to stand and continue to walk to booking area after he was injured. For purposes of 8th Amendment excessive force claim against sergeant under Section 1983, detainee alleged that the sergeant knew he was in severe pain but still forced detainee to stand and continue the walk to the booking area, even if Sergeant did not physically transport detainee to booking area to the extent that transport constituted a use of excessive force. Sergeant could be held liable on the grounds that he had a realistic opportunity to prevent the harm caused by officer's use of excessive force, but failed to do so. There's no evidence that one of two named officers was personally involved in use of excessive force against arrestee, as required to support arrestee's 1983 excessive force claim against such officer. So evidence, again, the facts, proof of facts. That's what we're focusing on today, folks, is proof of facts. Off-duty officers. So, all right, so deprivation of constitutional rights. All right, do we get numbers? Anyone? I need some numbers. Someone give me some numbers. All right, we're going to skip ahead to the numbers I've already been given. It's 12.7. So let's get to 12.7. Actually, I can just zoom to them from this thing here, and I'll have them on screen as I pull them up, so maybe you see something here that you get. So failure to investigate, 12.7. All right. It has been determined whether a failure to investigate constitutes a municipal policy or custom. So it has been determined. Cases. Condominium association on one side for disputes, condominium fell adequate. Let's see if there's any good ones here. There's a lot. Let me just read through them really quick here. County was not liable for violating parents' procedural due process rights based on children youth services agency caseworkers' alleged deviation from the requirements of Pennsylvania. Oh gosh, the pedophile Pennsylvania's Child Protective Services Law (CPSL) absent evidence that the county agency had a policy of or custom of conducting inadequate investigations into allegations of child abuse. Oh God, all right. We gotta get better stuff than this. Okay, sheriff's after the fact approval of investigation into deputy sheriff's use of force against arrestee, which did not itself cause or continue harm against arrestee, was insufficient. You get injured, I guess. Yeah, a lot of these are dark. Okay, we get some numbers. Oh, Scott's got some numbers for us, finally. All right, thanks, Scott. 20, 21, and 22. Let's do it. So, let's see here. 20, deliberate indifference. Conduct by law enforcement officials has raised special conceptual problems for the courts. On one hand, there is a concern that actual municipal culpability should not be masked and final responsibility avoided by overly rigid interpretations and applications of the concepts of the policy or custom, policy-making authority, and causation. On the other hand, there is concern that a backdoor vicarious liability principle should not be developed by overly tolerant interpretations and applications of those same key concepts. So, what we're trying to say here is that there's certain conceptual problems for the courts. So they should not have the culpability should not be masked and final responsibility avoided by overly rigid interpretations and applications of the concepts of policy, right? On the other hand, there's concern that a backdoor vicarious liability principle should not be developed by overly tolerant interpretations and applications. So they're looking at, they don't want abuse of, why do that? They don't want abuse of the systems, but, of the municipalities, I should say, but at the same time, they don't want they can't have policies and code overstepping law. So, in a way, I can kind of, I get it. One more second here. I got to do this one more time, guys. All right. And that should do it. Okay, so let's get back where we were. 20. So the attempt to limit the wide application of Section 1983 to municipalities and thereby prevent its use as a tool for imposing vicarious liability sub rosa is most obvious in the requirement that the policy of the municipality amount to one of deliberate indifference. See, we hear that term again. So deliberate indifference is meaning that they're not being indifferent just by accident or occasionally. Is that they're considerate of particular discriminatory practices and biases, and that they're deliberately indifferent to them. So that's in quotations. So at some point, that's a good question to pose or to investigate. Is there a deliberate indifference? This is getting to the cause, the intention here, because there's a bias that could be part of the intention. So a deliberate indifference eliminates that bias. But if there's no deliberate indifference, there could be a bias. So the deliberate indifference standard is viewed by most courts and commentators as a development of the concept of causation under Section 1983. Under Monell, a municipality could only be liable where action pursuant to official municipal policy caused a constitutional tort. The policy, whether an act or a failure to act, could not alone justify municipal liability. Interpreting the causation requirement of Monell led most courts to a fault-based analysis. Listen to this, fault-based analysis. Fault was generally defined as ranging from gross negligence to deliberate indifference. Standards always short of specific intent. Wow. Only where a municipality was found at fault, be it through gross negligence, recklessness, or deliberate indifference, could its policy of inadequate training be said to have caused the violation. Only where it was found at fault, be it through gross. Okay, so keep this in mind, guys, is the success, the win here. Only where the municipality was found at fault, and whether it be through gross negligence, recklessness, or deliberate indifference, could its policy of inadequate training be said to have caused the violation. So you can't say policy or training caused a violation unless you're going for the municipality. You can't be going over the employee if it's because of inadequate training. Inadequate training, only the municipality was at fault. That's your cause. The cause, in other words, the inadequate training of the employee might have been part of the violation, but the cause, according to, we'll look at footnote 25, the cause of the inadequate training can only be applied the fault to the municipality based on this fault-based analysis. So, strange that may seem, no common sense. Exactly. But what can we do? This is the state of the courts right now, and we can either sit here and throw our arms up and let them just totally take the common law out of the courts, or we stand for what it is, and this is where we're supposed to stand up and practice this at such an advanced level that they can't get away with this anymore. All right, let's continue here. We go on and on with this fault. We're back to the Monell. This goes on and on. Finally, the court held that for liability to attach, the identified deficiency in a city's training program must be closely related to the ultimate injury. The question is whether the injury would have been avoided had the employee been trained under a program that was not deficient in the identified respect. The court noted that in this case, decided only questions concerning policy and did not reach issues surrounding custom. At least one court, however, has indicated that it views the holding in Harris to be equally applicable to policy and custom cases generally. The Harris decision could, therefore, not only reach not only cases of inadequate training, but also any case of municipal liability involving a facially valid policy. So policy is valid on its face could still reach that too. So it's an interesting way of approaching it. They're letting you know there's some avenues here that might be very fruitful as far as legal strategies go in navigating the nonsense that we see all over the place. All right, let's get on here to transportation of handcuffed prisoners. We got to read this one. Receipt of complaints that injuries were occurring to arrestees while they were being transported to police station in the back of police wagons, which lacked safety restraints, did not establish that City Board of Police Commissioners was deliberately indifferent to conditions posing a substantial risk for serious harm to arrestees, as would allow recovery under 1983 action by pretrial detainee who was injured when he was thrown forward in the wagon's bulkhead while riding with his hands behind his back in handcuffs, where, with one exception, prior complaints related to minor injuries or allegations which did not involve any injuries. To hold county liable on deliberate indifference theory for injuries that he alleges sustained due to the county's 9-day delay in providing him with appropriate medical treatment for fractures to his head, pretrial detainee had to prove that the county had policy or custom of deliberate indifference that led to the violation of his 14th Amendment due process rights. He had to show that the county had custom or practice of permitting such deliberate indifference, and the county's custom or practice was moving force behind the constitutional violation. So there it is, 11th Circuit, that's Georgia, Floyd County. So lots of stuff here. We're on 21, proof of deliberate indifference. The parameters of the evidence sufficient to prove that a municipal policy reflects deliberate indifference to the constitutional rights of citizens are not entirely clear, in large part because of the relatively recent vintage of the Harris decision. However, some observations can be made which should be helpful to counsel. Counsel, I love it. See, we're counsel here. Counsel is a constitutionally protected right. As discussed in the preceding section, the Harris case itself uses an excessive force scenario as an example of proof of deliberate indifference. The failure of city police department to train police officers in the constitutional limitations on the use of deadly force would constitute deliberate indifference to the constitutional rights of suspects because the city knows, to a moral certainty, that its armed officers will be required at times to use such force in their attempts to arrest such persons. Therefore, whenever the duties of police officers are certain to put them in situations in which the constitutional rights of citizens may be violated, the failure of the municipality to instruct officers on the constitutional limitations on their powers may constitute deliberate indifference to those rights. Examples of such situations would include arrest and other detainment or restraint of suspects, custodial interrogations, and searches. In addition, where police so often violate constitutional rights that the need for further training must have been plainly obvious to the city policymakers, failure to provide such training amounts to deliberate indifference to that need. Consequently, the failure to correct any obviously constitutional practice would also be the evidence of deliberate indifference. So it can be assumed that the standard of deliberate indifference falls short of the requirement of specific intent. Though some commentators have asserted that the distinction between the two is uncertain at best, the differences could prove crucial in getting a case to the jury. At the very least, the deliberate indifference standards lessens the likelihood that a plaintiff will be required to show a specific affirmative decision by policymakers to persist in policies which result in the constitutional injury. The deliberate indifference standard makes the general acquiescence of policymakers in constitutional injurious policies more likely to serve as a foundation for liability. So let's make this great tip here and think that we have to dig in here to find these little gems, but that's what I love about American jurisprudence. So let's see here. Here's our distinction. At the very least, so let's keep it simple, deliberate indifference standard lessens the likelihood that your plaintiff will be required to show a specific affirmative decision by policymakers to persist in policies which results in constitutional injury, meaning that they don't have to show, something where they have an affirmative decision. Someone says you must do this, and it's going to persist and make the policies happen over and over. Constitutional injuries. You don't have that burden if you take the deliberate indifference standard. It lessens the likelihood, I should say. And deliberate indifference standard makes the general acquiescence of policymakers in constitutionally injurious policies more likely to serve as a foundation for liability. So the general acquiescence of the policymakers, they're just generally going along with it, not piping up and saying, hey, this isn't right. That makes them more likely. So keep this in mind. Standard of deliberate indifference. The standard of deliberate indifference. It doesn't require specific intent, requires a lot more to substantiate it than deliberate indifference. But they'll both suffice, so why not pick the one that's easier? Okay, case illustration, I love it. An off-duty police officer was beaten up in an altercation with one of the plaintiffs at a motel bar. Excuse me. The officer called his department, Daddy, and reinforcements came. And the entire night watch responded. They followed plaintiffs to a motel room, armed with nightsticks, clubs, bats, tire irons, and a fire axe, in addition to their service revolvers. The officers broke through the motel room door and savagely beat the unarmed plaintiffs. Plaintiffs asserted an unconstitutional police department's custom of breaking down doors without a warrant whenever its officers were apprehending a felon. There was testimony that the warrantless entries were customary in the department. Although there was no direct evidence that the police chief had actual knowledge of this policy, the evidence supported the finding of his constructive knowledge of it. Constructive knowledge. Actual knowledge and constructive knowledge. The chief utilized an extensive report review process to monitor the conduct of his officers, which alerted him to the practices that transgressed department policy. Allowing this custom to continue amounted to a deliberate indifference to the rights of the citizens of the city. The Court of Appeals therefore affirmed jury verdicts against the municipal defendants under Section 1983. That's a good story. Man, this is the stuff that makes it to the law books. Better than TV. Prior to the Harris decision, several circuit courts had used standard referred to as gross negligence amounting to deliberate indifference. Others had used terms gross negligence and deliberate indifference interchangeably. At least one circuit court decision issued after the Harris case has continued to use the gross negligence amounting to deliberate indifference standard. To what a standard more closely resembling gross negligence than specific intent remains viable after Harris remains to be seen. So, there it is. You want to try the gross negligence, have at it, but deliberate indifference sounds good enough for me at this point. So, let's see. Okay, that was a good case there. We can move on to the next one. See if there's a district here now. A lot of cases here. So you see, as we pick one topic, lots of cases. I usually pick like the first one, and maybe if you have a good example like we just read there, those are the best. All right, geez, there's a lot here on this section. Goodness. This is why I love proof of facts. I mean, if you have a particular case with one of these topics, you're going to find a similar case here. Not passing, am I? All right, we're just going to zoom it up here because it's just quicker to find it from this thing. All right, we're on to, what was it, 20? Do we hit 22 now? Evidentiary issues. So the fact that civil complaints alleging excessive force have been filed against one or more members of the city police department does not constitute evidence of the city's deliberate indifference to its failure to train or supervise police unless a complaint has been substantiated through a judicial or administrative proceeding. A civil complaint is merely an assertion of wrongdoing. It may not lead to a finding that an officer used excessive force. However, the investigation of a complaint has been found to be deficient. That fact may be relevant to the indifference of the city towards use of excessive force. So let's see here. A city cannot be held liable based on the general indifference of the city to its responsibility to supervise its police officers. Rather, plaintiff must show the city was knowingly and deliberately indifferent to the possibility that its police officers were likely to use excessive force. So there it is. On the general indifference of the city to its responsibility to supervise. You have to supervise your police officers. That won't work. Rather, plaintiff must show that the city was knowingly and deliberately indifferent to the possibility that its police officers were likely to use excessive force. So, all right, we'll continue down here. And, all right, here we go. I love the motorist one. So let's look at this case here. Motorists failed to demonstrate that city or former chief of police acted with deliberate indifference towards the rights of motorists with respect to policies regulating the use of force and traffic stops. Motorists did not support his conclusory allegations with a specific policy or a single other incident in which the city's failure to train led to use of... Okay, so losing case there. All right, too many of these dark cases here. All right, motorist allegations that police chief received notice of patrolman's alleged unconstitutional behavior and failed to stop it were insufficient to support their 1983 claims for supervisory liability related to patrolman's alleged Fourth Amendment violations in connection with motorist traffic stops, absent evidence that the chief subjectively knew of and deliberately disregarded substantial risk of unconstitutional harms posed by patrolman. While a subordinate officer investigated all complaints against patrolmen and disciplinary action had been taken when the complaints were supported by investigations, there was no showing that chief subjectively believed that patrolmen nonetheless posed a substantial risk of unconstitutional harm to others. Yeah, sure. Give me a break. Oh, this one looks, geez. All right, this looks like an exciting one. City was not deliberately indifferent to arrestees' Fourth Amendment rights by failing to prevent police officer. Okay, so the city was not deliberately indifferent to this guy's Fourth Amendment rights by failing to prevent police officer from using stun gun when detainee presented no immediate threat, but refused to change from street clothes into orange jumpsuits during booking, and the city was not liable for any violation of arrestee's Fourth Amendment rights for the police officer's use of stun gun after arrestee refused to change from street clothes in an orange jumpsuit during booking, which resulted in de minimis injury in arrestee's 1983 action against the city. There was no evidence of pattern of unreasonable use of stun gun by police officers, and it was not clearly established at the time of incidents that force resulting in only de minimis injury could violate Fourth Amendment. Jeez. So these are really bad, nasty, freaking cases. We go on and on and on with this stuff, but I don't see anything else here. It looks body cavity searches. Yeah, I'd rather just if there's something here catch anyone eyes, just let me know. I'm trying to keep up with the chat. Got a couple more here. We have 26 and 27. Let's look at those. Let's see here. Yeah, there's a lot of cases here. What's the end there? Okay, practice applications. See, 23. All right, well, let's look at this because this is good because this is the practice applications here. Let's just briefly read some of this. In pursuing an excessive force case under Section 1983, there are several practical considerations which should be kept in mind. First of all, plaintiff's counsel may assert alternative theories of liability at trial, such as deficient training policy or the condemnation of an unconstitutional custom, and non-cumulative liability may be found on the basis of either or both. With regard to investigation and discovery generally, interrogatories are not desirable discovery devices for gathering substantive information and should be used for such purposes only in low-budget cases. Interrogatories are best suited to discovery of identity of documents and witnesses. You get that? Interrogatories are best suited to discovery of identity of documents and witnesses for discovering identity. So interrogatories are basically yes-no questions that you give the other party. Generally, the answers will be form answers and therefore will not be candid. See, you're going to give them select from this. So testimony by an expert witness may help the plaintiff survive a motion for directed verdict. An excellent expert is a former prosecuting attorney who dealt with a particular municipality or police department at the time of incident and who can testify as to the existence of long-standing methods of misconduct employed by the city. Okay, so in a Section 1983 excessive force action, the defendants usually are the municipality, one or more police officers, and the officer supervisors. You get this? In a Section 1983 excessive force action, the defendants usually are the municipality, one or more police officers, and the officer's supervisor. As a matter of strategy, the plaintiff's counsel can benefit from the inherent potential conflict of interest between the police officer and the municipality. Hear this? Hear this. Counsel can drive a wedge between the officer and the municipality, encouraging the understandable tendency of each to blame the other for causing harm to the plaintiff. For example, the individual police officer may be naturally tempted to testify that he or she performed as well as possible under the circumstances, but was inadequately trained by the municipality. A representative of the municipality may testify that the officer's training was proper, but that the officer was not acting in accordance with that training. Okay, you guys catching this is good stuff. Further, the defense of good faith has been uniformly recognized as precluding liability on the part of the individual officer. But this defense is not available to a municipal defendant in a Section 1983 action. Thus, the defense that the police officer acted in good faith during the altercation based on his or her training or instructions from the municipality may absolve an individual officer of any liability while leaving the municipal employer liable. You get that? So good faith might get the guy off, but he won't get the municipality. It won't get the municipality off. That's when he throws the municipality under the bus. He acted in good faith. So now we get to the nuances here. I hope everyone's still with me. Checking out the numbers here, where we're at. Wife, who was a bystander to alleged police beatings of her family members, had standing to raise 42 U.S.C. 1983 claim where she alleged that officers violated family members' constitutional rights under 4th and 14th Amendments when they wrongfully entered home and unjustifiably beat family members within home. Boy, a lot of those cases, cops going in and breaking in and beating people, huh? Jeez. These are all like new cases, too. It's 92. It's not too new. It was newer. All right. Parties in standing. So here's going to be a lot of things with standing in that, but we want to get on to 26, 27. All right, see what's next here. What we have here, 26.5, 26, 26.5, and 27. So, yeah, damages. So, in an excessive force action under Section 1983, a municipality may be subject to both civil rights damages and actual damages. Civil rights damages are those which flow simply from the violation of a person's civil rights without regard to any physical, emotional, or other actual injury. These damages are highly significant, even if nominal, since they give rise to recovery of attorney fees under Section 28. Thus, when actual damages are absent, nominal damages will be the key to the plaintiff's case. Nominal damages, you get that? Okay. Actual or compensatory damages are recoverable under the provisions of Section 1983. The compensatory damages recoverable generally will be the type seen in other tort actions for personal injury, and include damages for physical and emotional injury and attendant expenses, costs, and impairment. These damages are more ascertainable than civil rights damages, and juries are more inclined to award verdicts when actual damages exist. Actual damages. Although punitive damages are available in Section 1983 suit against an official in his personal capacity, a municipality is immune from punitive damages. Cases. Okay, it's here. This is a short one. Let's read this one here. In a Section 1983 action for excessive use of force against an arrestee, a damage award of $216,000 was proper, where the arrestee suffered serious and painful injuries from fractured cheekbone. The injury required him to undergo general anesthesia surgery, and then left the left side of his face was permanently numbed by the injury. All right, so these are pretty dark here. Sufficient evidence supported by jury's award of $2,500,000 for pain and suffering to estate of father who was shot to death by estate. See, this estate of the father by off-duty police officer. Jury could reasonably conclude that the father, who saw a gun before he was shot and looked horrified and grimaced at passerbyers after he was shot, had suffered mental anguish of knowing he was going to die, and suffered intense physical anguish of being shot. Shit. Man. Award of $150,000 non-economic damages, including $100,000 for pain and suffering to arrestee who sued city for injuries sustained when, after being handcuffed by police who arrived at the scene of domestic disturbance, his throat was cut by the person with whom he had been fighting. Did not shock the conscience and thus did not warrant remitter or new trial. God. Gosh. All right, so these are dark here. Let's move along. See if there's anything good in there. And now we're on to punitive damages. See if we have a good one here. Town's motion to dismiss for failure to state claim under 42 U.S.C. 1983 is denied. Cool. Since arrestee alleges... since arrestee alleges town police officers, pursuant to town policies of tolerating police misconduct and siding with particular restaurants as a result of bribes. Oh, God. Arrested him without cause after he was assaulted at restaurant. Failed to arrest assaulters, although arrestee's parents identified them. Ignored his need for medical aid and took him to police station rather than hospital. Beat him and charged him with battery. Gosh, jeez. So they beat him and then charged him with battery. But punitive damages claims is dismissed as not recoverable against municipality. Because they try to get the money from the municipality. They should get it from the officers. All right. See, we learned something here. I mean, you learn from people's mistakes, too. Punitive damages were not available against the individual officers in their official capacities in arrestee's 1983 suit. Suit against an individual in her official capacity was a suit against a municipality. In her official instead of her individual capacity. And since a municipality cannot be liable for punitive damages, neither could an individual sued in her official capacity. Individual capacity, official capacity. Wow. All right, so we learned something there. And our checklist. Elements of actual damages. Are you guys ready? This is the best part here. Testimony about the following elements of actual damage should be elicited, when applicable, from the plaintiff's witnesses in an action against a municipality under Section 1983 alleging use of force by law enforcement officers. Guys, this is how the rubber meets the road here. So here's our checklist. Damages recoverable damages recoverable by or on behalf of injured person. So necessary and reasonable medical expenses, actual past expenses, anticipated future expenses. Then we go on to loss of past and future earnings, actual loss and loss of existing vocational skill. And see, we have references for all this through 15 AmJur, the proof of facts. We also have, for loss of past and future earnings, we have loss of capacity to earn increased wages and loss of profits or net income by person engaged in business. So you get add all these up. See, this is how we come up with our numbers, and then you present this in such a way it's so rational, reasonably logical that it's hard to argue. You know, the juries usually say this makes sense because look how much sense it makes. Cost of hiring substitute or assistant. Cost of hiring home care attendants for cooking, cleaning, and the like. Cost of occupational therapy or training. Harm from conditions caused by prolonged immobilization, such as thrombophlebitis, and pneumonia. Gosh, pain and suffering from physical injuries. Pain and suffering reasonably likely to occur in the future. Then, I love this one, phantom pain and other subjective pain not readily apparent to layperson. And mental anguish, fright and shock, anxiety and depression, other mental suffering or illness, anxiety to future disease or condition, physical injuries caused by mental anguish. So we got all these different law reviews and proof of facts and things, references for all of these things we're saying here. These aren't just coming off top of anyone's head. This checklist is well established from case law. So harm from loss of sleep, sexual dysfunction, insomnia, loss of smell, wow. Past and future impairment of an ability to enjoy life. Oh man. Then damages recoverable by heirs or dependents of injured person, loss of consortium, loss of household services from killed or injured spouse, parents' loss of minor services, loss of financial support from descendants' earnings and other income, loss of parental advice and guidance, loss of companionship of descendant, mental anguish and grief of survivors, loss of prospective inheritance as a result of death of injured person, funeral and burial expenses, and then attorney fees. Civil Rights Act 76 codified 42 U.S.C. 1988 provides any action to enforce certain civil rights actions, including Section 1983 Title 42, in the court discretion may allow the prevailing party other than the United States a reasonable attorney fee as part of the cost. The intent of the act is to encourage private attorneys general to correct abuses of civil rights. To effectuate this intent, courts have permitted plaintiffs, nearly as a matter of right, to recover attorney fees if they prevail on any significant issue in the litigation. In contrast, defendants may recover attorney fees only if the lawsuit is meritless, frivolous, or vexatiously brought to harass or embarrass the defendant. Furthermore, so this is interesting and footnote here for this too. Furthermore, the plaintiff may be considered to be a prevailing party in circumstances which fall short of a favorable judgment on all issues. Plaintiff may be considered to be the prevailing party, even if... Hang on a second, guys. Is my chat even working? It's a good question here. Yeah, I guess not too many people are still here, but I'm going to continue. Okay. The plaintiff may be considered to be the prevailing party, even if he does not win on all issues, or even the central issue. The claim is settled or mooted prior to trial. So that means the plaintiff will still be the prevailing party. Only nominal damages are awarded. A favorable settlement is agreed prior to trial. A fee may also be granted in a case where only injunctive relief is obtained or only limited monetary relief is obtained. However, courts have applied A bright prospect standard to find that where the merits of the case, the likelihood of the successes or damages involved are sufficient to attract competent counsel, the court has discretion to deny an application for counsel fees. This is because counsel in such cases can easily be obtained on a contingent basis, and since the principal statutory purpose is not served by an award of fees in those circumstances, the addition of counsel fees to a judgment may be considered unjust and denied by the court. You can still ask. All right, so there it is. We can find out more about the money side of recovering it for our practice here, but that's not the topic of our discussion. So let's go to the last one I wanted to go over here was number 31 someone mentioned. Let's see if it's worth looking at because I don't see them in the chat. So is there a third? There it is. Excessive use of force by arresting officer. Oh, Lord, these things are great. Okay, so the proof that the officer's use of force was in accordance with the municipal policy is testimony or other excessive force complaint. So after introduction of the witnesses. So here we go. This is a test excessive force by arresting officer. How old are you? Answer, 38. Are you employed? Yes. How are you employed? I am a barber. Directing your attention of the evening of, do you recall what you're doing? Yes. Do you know the defendant, the arresting officer? Yes, I do. How do you know him? From what happened that evening? What happened? He stopped my car. Were you driving? Ooh. Yes. I'd say I was driving. I'd say I was moving my property, maybe. Where were you driving? To my home. Where were you driving from? From work. In what city were you driving? Defendant, municipality. Do you recall the name of the street on which you were driving when you were stopped? Answer. What time was it you stopped? Recall. Answer. What, if anything, were you doing before you stopped? I was smoking and I dropped a cigarette in my lap. I had put my blinkers on while trying to keep from burning up my suit. Did you look to see if there was any traffic behind you when this happened? Yes, there wasn't any I could see. How far from home were you when this occurred? I was right near the driveway, fixing to pull in. Did you slow down while you were trying to avoid burning your suit? Yes, somewhat. What happened after that? All of a sudden, officer so-and-so came behind me with his lights on, pulling me over. Did you pull over when he did that? Yes. Did you remain in the car after pulling over? No. What did you do? I had parked my car and I got out to let him know why I had slowed down to tell him about dropping my cigarette. What happened then? Before I could say anything, he just said I was impeding traffic and I was drunk. Oh, look at this. Admissibility of statements by party or party's agent. Extrajudicial statements by a party to an action, whether made directly by the party or through a duly authorized agent, are admissible in evidence against the party if the statements tend to prove or disprove a material fact in the case. Under the federal rule of evidence and similar state rules, statements by a party's agent or employee may be admissible against the party if the statement concerns as a matter that was within the scope of the agency's employment and if the statement was made during the existence of the agency or employment relationship. Wow. Okay. What was your response, if any? I tried explaining that I wasn't drunk and I tried to show him where I had burnt a spot in my pants. Had you been drinking? No, I hadn't. What did he say, if anything, when you tried to explain the circumstances? He told me he didn't want to hear that I was drunk. What happened then? I started to go back to my car to close the door because there were receipts from the day in it. Why did you decide to get back to the car at that particular moment? I could see he was going to take me in and I wanted to lock my car. Did you tell him what you were doing? Yes. What did you say, if you can remember? I just said, let me lock up my car. Did the officer allow you to do that? No. What happened? I started to go back, but he grabbed me, swung me around, threw me against a police car, and handcuffed me. What happened? If anything happened when he swung you around? He pushed my head forward and smashed it into the top of the car a couple of times. So he was just serving and protecting him. How many times specifically can you remember? He did it twice. Were you injured by this? Yes, I was. How were you injured? My lip busted. It was bleeding. And my forehead, my right eye got bruised up pretty good. At this time, did he say anything to you? Yes. What did he say? He said, I'm going to teach you some lessons about driving up road in these big cars stopping traffic. Did he say anything else? He said I was under arrest. After you were thrown against a car and handcuffed, what happened? Put me in the police car and drove me to the police station. Were you charged by the officer so-and-so with driving while impaired? Yes. What happened in the case in court? Charge dismissed. Did you attempt to file a complaint over the way Officer Dickhead treated you? Yes. How'd you go about that? The magistrate on duty there. I complained to him the day I was arrested. What was his response? He gave me some papers to fill out. Was this a written complaint form, if you know? Yes, that's what it was. Did you file it with the police department? Yes, I did. Have you ever been notified about the status of this complaint? Yeah. No, because it's in the garbage can. I am showing you a document that has been marked for identification as plaintiff's exhibit and ask whether you can identify it. Yes, what is it? It's a copy of the complaint I filed. Is that your signature at the bottom? Yes, it is. Were you ever contacted in any way in regard to this complaint? No, I wasn't. To your knowledge, has any further investigation been made of your complaint? Not that I know of. Testimony of lying non-arresting officer, failure to train. Was your present employment? Police officer, city of municipality. Have you ever been the police force of the city on more than one occasion? Yes. How many times? Shit. Twice, including the present time. When was your first time in the department? I started in and left about late. Okay. When you first came to the department, who was in charge of your initial training? It was Sergeant Asshole. Would you describe the training you received at the time with regard to the treatment of arrestees and detainees? We were taught to respect people. All right. Opinion testimony by lay non-expert witnesses. If the witness is not testifying as an expert, the witness's testimony in the form of opinions or inferences is limited to those which are rationally based on the perception of the witness and helpful to a clear understanding of the witness's testimony or the determination of a fact in issue. Courts commonly receive in evidence the opinions of non-expert witnesses on a wide variety of subjects. Usually the admission of such an opinion is a matter of expediency or necessity, for it frequently happens that it is impossible for a witness to detail all the pertinent facts in such a manner as to enable the jury to form a conclusion without a statement of the witness's opinion. That's an interesting statement. Impossible for a witness to detail all the pertinent facts in such a manner as to enable the jury to form a conclusion without a statement of the witness's opinion. Wow. Okay. So, would you describe the training you received? We were taught to respect people. Would you explain what you mean? Shit. We were taught to put ourselves in the position of the person being beaten, arrested, or detained. We treated them as human beings. We were taught to remember that there was a human element involved in any arrest or contact we had with individuals. How was this taught to you specifically? We were instructed to do those things. Were you actually told these things by instructors? Yes. How was it taught to you in other ways as well? Yes. How? In the way you confronted situations, in being taught not to use force in situations where it's avoidable without endangering yourself, in being taught to be reactive to verbal abuse, not to be reactive to verbal abuse from someone on the street you're dealing with. After leaving the police department, what did you do? I went to work for the state as a police community relations consultant, Dick. Then I became the director of law enforcement education program at the state university. How long were you in these positions? The first job. Okay. When you rejoined the department, deadbeat, did you go through training all over again? Yes, I did. Who was in charge? Who is defendant, Dick? What would you describe the training you received that time with regard to the treatment of arrestees and detainees? It was very aggressive. How do you mean? It emphasized dealing with arrestees or detainees in a forceful physical manner. Do you remember a particular saying that was used by training officers to describe this type of aggressive behavior? Yes. What was that saying? Kick ass and take names. Can you recall the name of any officer in particular who you personally heard use this phrase? Yes. Who was it? Officer Rat. How many times would you estimate you heard him use that phrase? I couldn't count all the times. It was throughout the training period. From your experience, what was the difference, if any, in the training you originally received when you first joined the force and the training you received when you rejoined? My first training, we were taught it was better to talk to an individual than to try to fight the person the whole way. And the second time around, it was just the reverse. It was better to fight them into jail so the people on the street would know who was in charge. Question. During the training you received when you rejoined the department, what, if anything, were you taught to do if someone cursed you? We were taught that you did not have to take verbal abuse from the individual you're arresting. If they cursed you, knock the hell out of them. Jeez. What, if anything, were you taught to do if they assaulted you? You retaliated the same way. During the course of the training after you rejoined the department, did you have the occasion to speak to Chief of Police, a defendant, Chief, about your observations concerning the change in emphasis on physical aggressiveness training? Yes. What was the substance of that conversation, if you remember? Well, I just explained to him that I was concerned about it. That might be the right way to go. I told him that it appeared that the new style of training was resulting in an aggressive officer who would more likely to become involved in physical confrontations with persons on the street. Did you contrast the new method training with the training you received when you first joined the department? Yes, I did. How did he respond? Did he respond? Yes, he did. What was his response? He said that we have to let the monkeys know that they don't run the zoo. Did he use those words? Yes, I remember them well. Did he explain who he was referring to when he said the monkeys? No. Did he say anything else? He used the expression kick ass and take names. Then what officers who would do that? He said that people today didn't have enough respect for the law. The police were the thin blue line protecting the good guys from the bad guys, and the bad guys had to learn that if you mess with the bull, you get the horn. Were those words he used? Yes, they were. Sheriff and Sheriff's Department were not liable for failure to train Deputy Sheriff in the use of non-lethal weapons, absent evidence of deliberate indifference to a known risk of harm. There you go. Code of silence. All right, so we could go on with the code of silence on 33. I didn't see a request for 33. All right. Well, this has been a nice long stream here. We've gone, over 2 hours. And I'll say this, is that there's a whole bunch more left on here that we haven't even touched on. And I just encourage everyone that goes through the community post I made. And if there's anything else in here, strip search policy, police dogs, and that kind of catches your fancy, I'll be happy to go through this again because proof of facts is pretty long. There's a lot of cool stuff in here. And again, if there's time left on the next time, we can also go through some of the index here. Things like collateral estoppel and such. There's a lot of neat stuff in here that we could be going over that would help. Who knows? As you see here, these cases that are coming to court, there's some pretty bad things going on. And police misconduct as municipal policy or custom seems to be running a bit rampant these days. And if we don't have a remedy for it, it can only get worse. So it's up to us to make the change and to take action. And the knowledge and finding all the pitfalls and the application of the principles of the law through the common law is our best course of action, I believe. And with that said, I would like to thank everybody for coming tonight and spending time here on this stream. Again, I know there's a lot of other things out there that are a hell of a lot more exciting than reading through American jurisprudence proof of facts. But I believe the value we get from this is something that will pay us dividends many times in the future. Hopefully it won't, because like I always say, preparation is the best form of prevention. So that being said, I'd like to thank everyone again for coming, and please hit the like and the subscribe button and the bell notification so you can get notified next time I'm doing American jurisprudence or any of these other law-based on our rights and freedoms. The streams like this, you'll get notified because this channel is somewhat shadow banned, and I pretty much only get subscribers coming when they make sure they have that bell hit. Otherwise, it won't notify. Sometimes it doesn't even notify me, and I've had to scrub some streams. So, yeah, I try to put posts out in the community and be as vigilant as I can when I am doing these posts. But, yeah, having that subscription bell hit is probably your best bet to make sure you don't miss any. And with that note, I would like to thank you guys again for coming out, and I'll see y'all on the next one. Peace out.